Hi, everyone. Good afternoon and welcome. Thank you for joining us for our annual Stronger California Legislative Update webinar. We are thrilled to get to share with you all some of our 2023 Stronger California policy priorities for women and families here in our state. We will share information about some exciting and very hard-fought wins in the budget that we've already won, and also let you know about the Stronger California priority bills that are heading to their final votes when the legislature reconvenes next week from the recess, and as well as give you options about how you can support them. We do have a packed agenda, so if you have questions, please add them to the Q&A chat. We will try to touch on them if there is time, but we will also shoot you an email after the webinar with the recording, the slides, steps you can take to support the bills, and we will answer any questions we don't get to in that follow-up email as well. So without further ado, we can move to the next slide. I am really honored to be accompanied today by an incredible group of Stronger California advocates and partners. You can see all their beautiful pictures on the screen, and I'm going to introduce them each before they speak, but I encourage you to check out them and their organizations as well after the webinar to see the incredible work that they are all doing. So before we get started with our policy overview, we want to give you just a little bit of background about Stronger California. Many of you are longtime supporters of this network and policy agenda, but Stronger California is made up of incredible roundtable members, core group of roundtable members, and a group of network supporters. We comprise over 75 organizations from all around the state, and we are essentially a group that came together in 2015. And the goal was to bring together a diverse group of organizations and coalitions working on a variety of different issues, but all with interrelated interests. And the goal was, and still is, to organize around a collective policy agenda to promote gender, racial, and economic security. We engage collectively to advance our priorities each year through engagement in committee hearings, mobilizations of the Capitol, elevating awareness about these policies on social media, and really trying to get broad community support for our priorities. We also partner with the Legislative Women's Caucus and really try to lift up their leadership in these critical policy fights for women and families and others throughout the state. Our work is really grounded in the understanding that women and families and individuals throughout this state don't face barriers to economic security in silos. They really confront these obstacles all at once. And for that reason, we combat these intersecting barriers and obstacles to achieving economic security through a broad, comprehensive policy agenda aimed at addressing various and often intersecting barriers to economic security. So we, every year, organize our priorities around 5 pillars. You can see them listed here, and we're going to go through each one today. We, just this year, were thrilled to add this 5th pillar, health and reproductive rights, the first time we've added a pillar since we came together 8 years ago, to really address some of the critical issues that we see facing individuals in California regarding health and reproductive rights, and the really key tie that these issues have to economic security. Also, I just wanted to note that some of our priority bills are 2-year bills. So you will be hearing more about those next year when we reconvene and push them across the finish line, including our reproductive rights bills. But we will now turn to our first pillar overview, which is ensuring fair pay, job opportunities, and workplace justice. That is a key aspect, of course, of our comprehensive approach to achieving economic security. And so we're going to start with the priority bills on that pillar. So we can go to the next slide. Nope, forgot. We are going to start with a really exciting win before we get to the fair pay pillar. And this win is, as I said before, incredibly hard fought and really led by an incredible group of mostly women, but also allies across genders who have been fighting for access to affordable and quality childcare for years. And so I'm really pleased to introduce right now Jennifer Greppy, an incredible partner of ours and a friend. And Jennifer is the Director of Parent Policy at Parent Voices. So I will turn it to Jennifer to talk about our win on this pillar.
Yes. Hello, everyone. Oh, it's so great to be here today to share this really incredible victory with you all. It's been a really long, hard fight, and something that so many parents have, stepped up, done so many things to come to the Capitol in terrible rainstorms, to wait in long queues in budget hearings and in legislative hearings, and sharing their really personal stories about how these issues impact them, and educating our legislature as well as our governor's office about how the solutions that they find can be implemented in our state budget. And so without further ado, I will go into what our incredible victories were. So about 4 years ago, parents came together at one of our leadership retreats and talked about how, family fees were really impacting their family in such an incredible way. And they were having to pay hundreds and hundreds of dollars a month and thousands of dollars a year for their free childcare. And so, we looked at lots of different solutions. How can we fix this problem? And parents were like, maybe we can look at, net income instead of gross income, or maybe we can have deductions for certain, for rent or for bills. But then in the end, they decided, we want to just eliminate these fees altogether. And we did some research, found out that the federal government would not allow us to completely eliminate them. So what we did was get as close to elimination as possible. And so, like I said, we had 2 separate bills. We started out with AB 92 with Majority Leader Eloise Gomez Reyes. That was our first bill. And then in this legislative session, it was AB 596 and SB 380. That was 2 bills that were held by Senator Limon and Assemblymember Reyes. And in those bills, we were really trying to make sure that we were speaking with one voice about how we wanted to fix the family fee system. And so in the end, what we got was we were able to eliminate family fees for families making under 75% of the state median income. Which, what does that actually mean, right? So a family of 2 earning about $64,000 a year and below doesn't have to pay family fees anymore, right? And what that means to their family income is that instead of paying $6,418 a year in family fees, now once they start earning 75%, their fees will only be $648 a year, right? So we're charging no more than 1% of their family's income, making it really possible for them to save money to be able to pay bills. We all know how crazy inflation is, right? And how much everything costs, and every penny that goes into the budget for these families is extra money that they can use for groceries and gas and all of those things. And if you want to read more about just the incredible impacts of what this means for families, we're putting in the chat or in the somewhere a link to a really incredible piece of work that was done by the California Budget and Policy Center, and Parent Voices came together to do this really important report that shares stories of families and really tells the complete story. So we've eliminated family fees as we know them in California, and families are going to be able to save all of this incredible money. But what else did we do in the childcare space? We were able to eliminate the arrears that families were paying. So before the pandemic, families had these really intense and crazy payment plans that they had to pay every month in order to keep their childcare. And so we were able to eliminate all of those past payment plans. We were also able to, with the help of the child care union, and the union really worked so hard to get an incredible contract in this last year. and they were able to get a 20% increase, one of the largest increases ever for childcare providers in our state. They were also able to get some retirement funding and funding for medical benefits for union members. And, you know, it was really a blockbuster year for childcare, and a year that was really a challenging year budget-wise, right? But as we know, and as we saw during the pandemic and even before, childcare is such an essential piece of our economic, ability to have economic security here in California. And our governor and our legislature and all of our partners at the Women's Caucus, along with our legislative champions and all of you on this call who were there to support these bills and the budget ask. It took all of us to really speak with one voice so that we could eliminate family fees for families, make it easier and better for them to be able to access childcare, as well as to make sure that we are paying our childcare providers a wage that is dignified. And we are moving towards what we call a cost of care model, which is, we want to pay childcare providers what it actually costs to provide the care, which is not how we pay them currently. And so we have a way forward with that. We're really excited about where it's moving us, and we look forward to continuing to work with all of you to continue to build a childcare space that is fair and just and breaks down the racist policies of our past. Thank you.
Thank you so much, Jennifer. And I hope everyone is as pumped as I am to just hear this overview. Every time I am reminded by how much money families in California will now be able to put towards basic needs that they, diapers, rent, food, with this incredible win. It really inspires me all over again. So thank you, Jennifer.
Welcome.
Wonderful. So now we will turn to the fair pay, job opportunities, and workplace justice pillar. This is where we organize our priorities that have to do with issues relating to the workplace and workers' rights and ensuring that we have equity for workers in California. We have made a lot of strides and often lead the way for the rest of the country, but definitely still have room to grow in this area. So the first speaker I'm thrilled to introduce is Kim Alvarenga, the director of the California Domestic Workers Coalition, to talk to us about our first priority bill, SB 686.
Hello, everybody. It's so great to be with you here in this space. And first of all, I just want to thank all of the amazing Stronger California partners and organizations for their long-standing support of the domestic worker movement in California. Today, I am going to share some background and an update on SB 686, the Health and Safety for All Workers Act, that is, of course, authored by our amazing champion, Senator Durazo. Unfortunately, as many of you know, household domestic service workers have historically been excluded from many basic labor protections. These exclusions, as you know, are rooted in a long history of racism in our country. And we've been fighting to end that racism for a very long time. Currently, household domestic workers are one of the only industries that are not protected under basic occupational health and safety rights in California, and actually in the country. We've been working to change that over a few years. For years, domestic workers have been suffering injuries and illnesses with no recourse at all. Recently, a June 2020 report from the UCLA Labor and Occupational Safety and Health Program found that 85% of domestic workers surveyed experience musculoskeletal injuries that are associated with chronic pain. Many of those respondents, 94% of whom were Latino or Asian, reported continuing to work through their injuries for a fear of job or financial loss. Such injuries could be prevented by appropriate health and safety guidance and subsequent enforcement. 1 year into the COVID pandemic, as we all remember, domestic workers were 3 times more likely to have contracted COVID-19 than the general population in California. putting their lives at risk as well as their families and broader communities. Climate-accelerated disasters have also magnified vulnerability and dangers that domestic workers and also day laborers face on a daily basis. During the wildfires that devastated California, domestic workers and other household workers, such as day laborers, were asked to stay behind to fight fires, guard homes or pets, work in smoking conditions, and clean up toxic ash. Our work to finally win dignity and health and safety rights for domestic workers has been a multi-year effort. In 2021, Governor Newsom signed SB 321 into law, creating an advisory committee composed equally of domestic workers, employers, and occupational health and safety experts. This committee worked over a year to develop, and this is a key word, voluntary, industry-specific health and safety guidelines, and to make policy recommendations to the legislature on how to strengthen the health and safety of household domestic service workers in the home workplace. SB 686 advances two of those key recommendations, which are one, to finally remove the household domestic services exclusion from Cal OSHA, and to look to these voluntary industry-specific guidelines that took over a year to create. And two, to establish a financial assistance program for low-resourced employers to support them in complying with health and safety regulations to keep the home work setting safe for all. Where are we at right now in the process? Well, SB 686 is in appropriations currently and will be going into suspense file. So we're really hoping to get support from folks sending letters of support. We're also, as you can see, we have one of our flyers here on the slide here. We have a wonderful mobilization on August 29th in Sacramento. We'll be joined by the National Domestic Workers Alliance and other partners that day for our largest mobilization and rally of the year. So we invite you to join us and come and get a coalition t-shirt. Be part of the day on that day. Thank you so much, Si Se Puede. We need to make sure Governor Newsom signs this bill this year. The time has come.
Si se puede. Gracias, Kim. I would encourage everyone to join the rally, because anyone who has ever been to a rally led by the Domestic Worker Coalition, and also Parent Voices for that matter, it is an incredible showing and will be again on the 29th. So please do join us. We'll send out information about that event and hope you all can join up at the Capitol that day. Wonderful. So we're going to turn now to Dallas Fowler. Dallas is the Director of Public Affairs with the California Coalition for Worker Power, an incredible new-ish coalition and partner of Stronger California that really seeks to organize low-wage workers and ensure worker power in our state. And Dallas will be talking about an exciting equal pay and anti-retaliation bill that we are pleased to work on with her. So Dallas, I'll turn it to you.
Greetings, thank you. And it is a pleasure and an honor to be here with this wonderful panel and hear all of the amazing work that is going on. And yes, Si Se Puede, we stand strong as a coalition in support of SB 686 as well. The California Coalition for Worker Power, we are a group of worker centers, worker advocates, and labor policy experts and labor unions dedicated to ensuring that every worker in California has the power to come together and improve their working conditions. And so how did SB 497 come about? A member of one of our coalition members, which is NELP, the National Employment Law Project, did a study of 1,000 workers in California last year. And that study uncovered that more than 40% of workers have said that they have a concern about being fired or disciplined. And that concern has prevented them from joining coworkers to push for better improvements in their workplace. And an even greater share of Black and Latinx workers, 55 to 46%, also respectively say the risk of speaking out are just simply too high. And what we know as women in the workplace, and particularly women of color, when we raise issues about pay equity, we are often facing retaliation. 38% of California workers have experienced a workplace violation, but only 10% of those workers have actually reported them to a government agency. And then though almost half of those violations that took place, no one was ever reported to. So of the workers who have reported violations to their employers, more than 50% have experienced employer retaliation. So what that means is California workers are essentially suffering in silence. One of our coalition members, our coalition policy co-chair, Ruth Silver-Traub, who is the executive director of the Santa Clara County Wage Theft Coalition, actually helped us to draft this policy, and it was picked up by Senator Lola Smallwood Cuevas, who is my senator in the Los Angeles area. And essentially what this bill would do is it amends the labor code and allows the labor commissioner to readily identify when a protected act happens in the workplace and an adverse action has taken place within 90 days. So this bill puts what's called a 90-day rebuttable presumption on these protected acts. So a protected act means I raised an issue of pay equity, wage theft, workplace safety, workplace hazards, and then within 90 days, I was either fired, hours cut, or my location was moved to a place that's far for me to get to or very hard for me to access. And so this bill strengthens those retaliation protections, and it also allows for whistleblower complaints to have the right to be made. I mean, so if a whistleblower actually wins a retaliation case, then the employers may potentially be fined up to $10,000, and that penalty would, instead of going to the labor commissioner, which historically has been the case, the penalty fees would actually go to the worker. So this is, it's a really special bill. It's not hard. I think we're kind of flying under the radar. We aren't on the job killer list. I think primarily because a lot of the employers are already documenting the how and the why and the reasonings why they have fired folks. And if they don't have a reason, it allows the labor commissioner again to readily identify this as an act of retaliation. I will look and make sure. I think this is it. This is the bill, and in of itself, I think I've done this so many times now. I'm not used to getting through it so fast, but of course I will make my information available. And anyone who has questions and wants to contact us and support this bill, you are more than welcome.
You present it perfectly. Thank you, Dallas. We are so thrilled to ERA as a sponsor of the bill and to have it as a priority on the Stronger California agenda. The retaliation that Dallas discussed is so rampant and so problematic for all workers, but especially low-wage workers. We're thrilled. And thank you so much, Dallas, for your leadership on this. As many of you know who have been supporting Stronger California for many years, we have prioritized a number of bills to protect workers against retaliation and also to ensure equal pay. And this is the next very important step to ensure that those rights are not just on paper, that workers can actually assert them and have some type of justice if they're experiencing retaliation as a result. So thank you, Dallas. Next, I am going to turn to Beth Mora with Mora Employment Law and representing the California Employment Lawyers Association, a key leader in Stronger California since the very beginning, to talk about our final bill on the Fair Pay Workplace Justice pillar. So Beth, I will turn it to you.
Thank you, Jessica. Thank you everyone for having us. It's been very inspiring. I'm pleased to be here representing the California Employment Lawyers Association and to discuss an important Stronger California priority bill, AB 933, which will ensure that survivors of sexual assault, harassment, or discrimination who speak out about their experience have adequate protections against retaliatory defamation lawsuits. I have been representing workers for over 22 years. In my practice, I've represented numerous clients who have experienced horrific and traumatic sexual assault, sexual harassment, and discrimination and other forms of discrimination in the workplace, who have then been re-traumatized by meritless claims of defamation brought by perpetrators. Such claims are specifically designed to intimidate and silence them. This also is a growing problem in other areas, including in the realm of education, where student survivors are increasingly being threatened with, and in many cases hit with, defamation suits just for speaking out about assault, harassment, and discrimination that they have experienced. It is extremely difficult for survivors to speak out about their abuse, and the weaponization of baseless defamation lawsuits is a form of re-traumatization. These are individuals who have already shown tremendous courage by bringing a complaint, and who often have limited resources and cannot afford the cost of a defamation claim. Although the survivors may ultimately prevail in the end, this is a price of being, it is a price of being subjected to a lengthy, expensive, and re-traumatizing lawsuit. Many survivors are too fearful of even speaking out about the harassment, discrimination, or assault they have suffered because they fear being hit with retaliatory defamation claim. We have also seen this issue in high-profile cases in the news, which have a further chilling effect. AB 933 will simply make it clear that when a survivor speaks out about sexual assault, harassment, or discrimination, that is privileged speech. This kind of speech is often protected under current law, but because there are some gray areas, it can leave survivors open to baseless defamatory lawsuits and therefore costly and painful legal proceedings. AB 933 will ensure survivors of sexual assault, harassment, and discrimination are adequately protected from defamation lawsuits by clarifying that claims made in good faith without malice are forms of protected speech. This bill also provides relief to survivors in the form of reasonable attorney's fees and damages for successfully defending themselves against these retaliatory lawsuits. Through the Stronger California legislative agenda, we combat the myriad of challenges that women and people across genders face in achieving economic security. This bill will make it harder for perpetrators to retaliate against survivors with legal threats and intimidation. By helping to prevent these costly and retaliatory lawsuits, it will help protect survivors' economic security. This is an issue affecting survivors of all walks of life, from workers to students to lobbyists to even famous singers. Too often, survivors are being hit with these baseless and retaliatory defamation suits. This bill will protect their ability to speak out and stop the perpetration of abuse, not only protecting people who have experienced sexual assault and harassment, but also race-based and other forms of harassment and discrimination. It will also serve as a blueprint for other states to follow and enshrine similar protections throughout the country. I encourage all of you to ensure to support AB 933. Thank you.
Thank you, Beth. As we talked about from the beginning, we really take this comprehensive approach to ensuring economic security, and I really appreciate your highlighting how issues like these types of retaliatory defamation suits really can cause a great deal of economic insecurity for survivors who have to fight back and ultimately prevail, but have to go through these very costly proceedings. So thank you, Beth. We're going to turn now to Megan Abel. She is the Senior Director of Advocacy at Tech Equity Collaborative to round us out with our final workplace justice bill, ensuring protections for laid off workers. So I'll turn it to you, Megan.
Thanks so much, Jess. So we are sponsoring AB 1356, the Protect Laid Off Workers Act, which is authored by Assemblymember Haney. And we're also proud to have California Employment Lawyers Association, another member of Stronger California, as a co-sponsor, as well as Alphabet Workers Union, California Labor Federation, National Employment Law Project, National Legal Advocacy Network, and Temp Worker Justice. And this bill seeks to strengthen support for workers who have been impacted by mass layoffs. California has long recognized the need for a strong safety net to ensure stability for working families and economic prosperity for all, which is why the state 20 years ago expanded on the federal WARN Act to include protections for more laid off workers. Since then, the economy and the realities for workers have shifted dramatically, and we need to update protections to meet the needs of workers today. So our bill will grow the safety net for laid off workers, expand the protections to reflect the way that work actually happens today, and ensure that workers' safety nets aren't tied up in negotiations. Many of us know that Californians are struggling to make ends meet with a high cost of living. Over a third of Californians don't have 3 months of savings to cover basic necessities in the event of an unexpected job loss. And 56% of women report having no emergency savings at all. Workers in California need stability and fair warning when layoffs occur. So our bill seeks to expand the notice requirement for a mass layoff from 60 days with the current WARN Act to a 75-day notice, giving workers an additional 2 weeks to prepare themselves and their families in this really big financial transition. We also want to include contract workers in these protections. Contract workers are often working side by side with directly employed peers at these companies. And despite that, they don't receive the same protection as their directly employed counterparts. California's contract workforce is really sizable. It's 1.9 million employees as of 2021. But these workers aren't usually covered by the existing WARN Act and are already twice as likely to be paid poverty wages compared to workers who are directly employed, according to a study from NELP. They're also disproportionately women, non-binary, and people of color. Our bill also will prevent employers from negotiating away the protections that the WARN Act gives. Companies we've seen have pressured workers to waive their rights in order to receive their WARN Act notice through overly broad severance agreements. We need to decouple WARN Act guarantees from negotiations around severance or separation agreements. The intent of the WARN Act is to be a floor and a guarantee to workers. And so we want to make it clear within our law that this isn't something that employers can leverage or bargain over. I also want to highlight that layoffs are an equity issue. Getting laid off is a difficult experience for any worker, but some are more likely to get laid off than others. Studies have shown that companies often lose the gains that they've made in diversity during layoffs, decreasing the number of women and other underrepresented employees in their workforce through unconscious bias during layoffs. And unemployment benefits are based on previous income, not necessarily on need. So this means that not only do BIPOC folks and women get paid less wages on average while they're employed, but they also receive less support through unemployment benefits. And it often takes families years to financially recover from a layoff. Giving workers more warning hopefully will ensure that they have enough time to seek new employment before ever experiencing a gap in their employment. We know through our research that women and people of color are hit the hardest when layoffs occur, and AB 1356 will expand the safety net for laid off workers. So we're really thrilled to see this bill moving through the legislature. We're headed to Senate appropriations and shortly thereafter the floor. So if you're interested in getting involved in our campaign to support laid off workers, please feel free to reach out to me.
Thank you, Megan. Tech Equity Collaborative has done such an incredible job of lifting up how these issues, which might seem kind of in the weeds, really are affecting people on a broad scale, and especially, as you heard, contract workers who are more often women, workers of color, and non-binary people. So these types of protections are critical, and really appreciate all of the work for this priority on our agenda. Next, we are going to transition to our family-friendly workplaces pillar. We know that families face extreme obstacles to being able to work and care, workers being able to care for family members. So this pillar has a number of exciting priorities to ensure that workers have the supports they need when they are caring for family. So I'm going to turn first to Katie Duberg. She is the political organizing director with the California Work and Family Coalition, who is going to start us off talking about our paid sick days priority bill. Katie?
Thanks so much, Jessica. And it's really wonderful to be here today talking about this really important issue with such fabulous organizations and people. So SB 616 is authored by Senator Gonzalez. And it would require employers to let their employees earn and use 7 paid sick days every year instead of 3. Current California state law only requires that employers allow California workers to earn and use 3 paid sick days every year. And I think we can all agree that 3 days is not enough. We knew this before the COVID-19 pandemic, and the pandemic has really shown how inadequate 3 paid sick days is. In fact, 14 other states and the District of Columbia already require employers to allow workers to earn and use more than 3 paid sick days per year. And so do a number of cities in California through local ordinances. When workers lack paid sick days, they're forced to choose between going to work sick or staying home and risking their job or pay, which also jeopardizes their ability to meet basic needs like rent, groceries, and medicine. Missing 3.5 days of pay can be a family's entire monthly grocery budget. So no one should face this choice, but this is particularly important, we know, for workers who are earning low wages, who in California are disproportionately likely to be women, immigrants, and people of color. And they're far less likely to have employer paid sick days beyond the current state minimum. Californians can use their paid sick and safe days for their own illness or preventative care, to care for a family member, which could be a child or an older adult or another family member, or for reasons related to domestic violence, sexual assault, and stalking, which is why we like to call them paid sick and safe days. This is also really important for parents. There's data that shows that when a child is sick, mothers are more likely to stay home than fathers. And so there are a lot of different ways that paid sick days impact gender equity issues, but I wanted to be sure to highlight that for this audience. The bill is currently in Assembly Appropriations. We would love any support. I know we're going to drop a link in the chat to an action alert that allows people to really easily contact their legislators. And I think it's just really important for people who've had the experience of not having enough paid sick days to speak up and educate our lawmakers about that experience, to make sure that we ensure that workers can use an adequate number of paid sick days, which would be 7. So thanks so much, Jessica.
Thank you, Katie, for all of your advocacy and for highlighting this critical bill. I think any of us who have family members understand the need to have more than 3 sick days. So we really appreciate the leadership of the coalition and all the partners on this. Next, we are going to have Shazi Kamali, who is a staff attorney at Legal Aid at Work, present on our next priority on the family-friendly workplaces pillar, which is paid family leave for chosen family.
Hi, everyone. Like Jessica explained, I'm from Legal Aid at Work. It's a nonprofit legal services organization based in San Francisco, representing underpaid and low-income workers across the state. I'm here to talk about AB 518, paid family leave for chosen family, authored by Assemblymember Wicks. So AB 518 would allow people who are missing out on income because they're taking care of a member of their chosen or extended family to access the benefits that they're entitled to. So some background, the laws that require your employer to give you time off for family medical leave function separately from the benefits programs that pay you during a leave. So employers aren't required to pay you during an FMLA or CFRA, California Family Rights Act leave. So FMLA is the federal law, California Family Rights Act is the state law. It's a little bit less restrictive. But for people who are on a leave and are eligible, they can get PFL benefits through the state. So PFL stands for Paid Family Leave. It's distributed through the Employment Development Department, the EDD. PFL is a completely worker-funded program. It's funded through paycheck deductions, and you can claim your PFL benefits whenever you're experiencing a wage loss for a variety of reasons, like baby bonding, things like that. But you can also get it for caring for a seriously ill family member. This bill is about expanding the list of family members that you can get PFL benefits for. Right now, you can only get it from if you are caring for a family member who is on like a specific enumerated list, and that list is very heteronormative and also leaves a lot of people out, like uncles, aunts, cousins, and chosen family. So AB 518 would allow a worker who's paid into the fund and taking care of a seriously ill member of their chosen or extended family to be able to get PFL benefits during that time by allowing them to take care of a designated person, which can be anyone who is blood related or like family. This bill is really important for for members of the LGBTQIA family and people who are immigrants and or living in multi-generational households, because they often have to miss work to take care of a member of their extended family. And this is especially important for people who are low income or underpaid, because last year with AB 1041, we were able to expand the unpaid leave law that I was talking about earlier to require employers to provide time off to employees taking care of seriously ill members of their chosen or extended family. So this year, AB 518 will update the paid family leave program so that workers can actually receive wage replacement when caring for members of their chosen or extended family, which is really, really important because 3 months of no income is just not feasible for many people. And this would make caregiving leave like actually for a chosen or extended family actually a reality. And right now it's in Senate appropriations. So all the support that we can get is really going to be critical.
Thank you, Shazzy. What's so exciting about the Stronger California agenda is not only to see the impact that we're making here in California for workers, but this is an area in which other states are hopefully going to follow our lead. And there will be attempts at the federal level. It might not go all the way in this Congress, but we really do kind of lay a blueprint often for other jurisdictions to follow in this and so many other areas. So thank you, Shazzy. I'm actually going to next cover our final priority bill on the family-friendly workplace pillar, which is AB 524, also Assemblymember Wicks, and it is the Family Caregiver Discrimination Act. And this addresses an issue that we see a lot at Equal Rights Advocates and all of our co-sponsor organizations, many of whom are represented here, which is that workers who are also family caregivers, so they take care of young children, or sick or elderly family members, or a disabled family member, they often experience discrimination in the workplace because of the fact that they are family caregivers. And this really is often based on complete assumptions and biases and stereotypes about how workers with caregiving abilities should act or might act that is not based at all in their actual work record. We see this happening a lot for women, but it really happens across genders. And so this is an issue that, while it is still predominantly women who experience this problem, and so, for example, to give you some pretty scary numbers, one study found that mothers were 79% less likely to be hired, half as likely to be promoted, and offered an average of $11,000 less in salary for the same position as similarly qualified non-mothers. We do, though, see this occurring across genders. We see male workers who are fathers being penalized or looked down upon for taking parental leave because it is seen as appropriate for a mother to take parental leave and not a father, and for other workers, including non-binary workers as well. Especially important now that many workers are facing the sandwich generation reality of caring for both young children as well as elderly parents. We're really seeing this increase in problematic areas around work. We already have 4 other states and over 200 localities that have already passed protections for parents or other caregivers. So this is one area in which California really does need to catch up to ensure that caregivers are protected against discrimination at work. And this bill would do that. It would add family caregiver status to the list of protected characteristics under our state anti-discrimination law and ensure that workers cannot be treated adversely simply because they are caregivers. We are really excited to lead this effort. It's actually been over 10 years that we have all been advocating for this to pass. This is the furthest it has gone. So we are hopeful that it will make it through this time, especially with your support. It is now in Senate appropriations, so we will be circulating information, including take actions for how you can ensure that legislators hear from you about the importance of protecting workers against discrimination for being family caregivers, and hope you can join us in that effort. Finally, last but not least, I am excited to turn it over to Sabrina Ham. She is the Director of State Policy and Advocacy at Free From, a key Stronger California partner, and she is going to talk about a priority bill on our final pillar for today, which is building economic security by addressing poverty and building assets, and is going to talk about a priority that has also been a long time coming and a long fight, and hopefully we can get it through this year. So I will turn it to you, Sabrina.
Great. Thank you so much for having me today. I'm Sabrina Ham, the Director of State Policy and Advocacy at Free From. And if you are not familiar with our work, we work to create pathways to long-term safety for survivors of intimate partner violence, really focusing on the nexus between intimate partner violence and financial security. We are proud co-sponsors of AB 1082, Assemblymember Colra's bill. We are co-sponsoring the bill alongside Western Center Law and Poverty, San Francisco Lawyers Committee for Civil Rights, and Poverty in California, EPIC. And so what this bill will essentially do is it's aiming to end poverty towing. And so currently in California, cities can tow or boot someone's car due to one unpaid parking ticket. And the DMV can also place a registration hold because of unpaid parking tickets, which can have a cascading consequences on families and survivors on their financial security. And so losing a vehicle can be costly for people living in poverty. It means a loss to getting to work, earning an income, going to school, managing childcare, dealing with any sort of medical issues or any basic needs. And a loss can make it even more difficult for families who are struggling to get by, in particular Black and Brown communities who are oftentimes over-policed. And so for intimate partner violence survivors, a loss of their vehicle can also mean a loss of their only means for safety. And so after a car is towed, because of an unpaid parking ticket, the owner would be responsible for paying the fees to get their car at the lot. And if they're unable to pay for those fees, they lose their car altogether. And actually, a ton of research has shown that local governments tow hundreds of thousands of cars for non-safety reasons for each year, and actually don't make that money back with the costs associated with keeping the car in a lot and all those sort of things. And so this bill will do three main things: eliminate the authority to tow or boot a vehicle due to unpaid parking tickets, increase the threshold of the number of unpaid parking tickets before the vehicle owner is prevented from renewing the registration, and it also makes some improvements to the parking payment plans to make sure that that they can pay down their parking debts and make that payment plan much more accessible. And so this bill will help to make sure families and survivors can continue to drive to work, pay their bills, and provide for their families. And the bill will end tows for unpaid parking tickets and create a realistic payment plan so that folks can get back on track. And in a recent court decision, California Court of Appeals held that the San Francisco city's policy of towing a vehicle solely for unpaid parking tickets and for non-safety reasons. So blocking a fire hydrant, for example, is a safety reason. So for a non-safety reasons is unconstitutional. And so now California has the opportunity to codify this into law by passing AB 82. The bill is currently in Senate approves. It's scheduled to be heard on August 21st. Our main target right now is Portantino. So if folks have connections with his office or have meetings scheduled, it'd be really great if you all can continue to help uplift this bill and the importance of this bill for working families. The opposition is strong on this bill, and we certainly need all of the support that we can get, and I'll be happy to follow up with some letters of support. Thank you.
Thank you so much, Sabrina, and thank you for your leadership and for Free From's leadership in advocating for the rights of survivors. A key aspect of our Stronger California work has been, among many other things, to lift up the tie between ensuring economic security and preventing domestic violence and other forms of violence. And so really appreciate your work in this area, and really wanted to lift up that this pillar of combating poverty and building assets is really intended to, again, address kind of key contributors to poverty. So we lift up a lot of needs in the budget for anti-poverty programs within making CalWORKs more accessible, have our really incredible partners at Grace and Child Poverty, who we will be lifting up next year as we continue the fights in that realm to make CalWORKs accessible for more and reducing the really unfair barriers there. We also, though, lift up bills that really try to address asset stripping mechanisms like this one. And so really appreciate your tying that in here, Sabrina, of the ways in which families, women and others across the state experience these types of asset stripping issues that just kind of keep them in debt and cycles of debt and cycles of poverty. So thank you so much for lifting that up. We, as I mentioned, have a fifth pillar, which is our health and reproductive rights pillar, and we will be reaching out to you next year when our bills on that pillar are moving, the 2-year bills, as well as some of our other priorities, which are 2-year bills. I want to first lift up for everyone here that you will be receiving an email with all of this information about how you can support these incredible priorities. There will be a sign up where you can sign up for updates. There's a really cool QR code, which I believe you can hold your phone up to that on your screen, and it will take you to where you need to go, which is exciting new development on our tech savvy end. And also, if you are a member of an organization that wants to get involved with becoming a member of Stronger California, we would love to have you. So please do email me. My email is on the screen if you would like to be involved in Stronger California in that way. We have time for, we're not going to force you to go the full hour. So we're going to address 2 questions and let you go a few minutes early. But one of the questions is on the paid sick days bill, and it is whether SB 616 would allow unused sick days to roll over to the next year. So I will turn it to Katie to answer that question.
So thanks so much for that question. So yes, under current law, employees can roll over a certain number of hours, and that would still be true under SB 616. But employers can cap the maximum number of hours that employees can use per year. So that's what the 7 days would still be the maximum number of hours that someone can use in a year.
Thank you, Katie. And then the other question was, how have Stronger California policy wins impacted laws beyond the state, which we touched on a little bit. So I can just start, and then I just want to see if any of my co-panelists want to add in. Since our 8 years of working together as a Stronger California collective, we have celebrated over 43 wins, legislative wins, as well as secured billions of dollars in funding in the budget for all of these priorities. So the impact in California has been really strong and exciting. But what is really, I know for all of us, inspiring is that we've seen a number of states following our lead in different ways. And so we will send you kind of a list of the states that have followed our lead in some of our bills that we promoted, including our equal pay related bills, our family friendly workplace bills, some of our anti-poverty bills. And there are at the federal level some bills introduced and likely to be introduced on these issues as well, including that of chosen family and also caregiver discrimination. So we will send those legislators our support from California and show them how these policies have really played out successfully on the ground here to have that broader impact. But I do want to open it up to any of my co-panelists if anyone wants to add to that question. Just seeing if they. Okay. All right. Well, we want to make sure that we wrap up on time. So we will, I see a request for contact information. I'm going to put my contact information again in the chat, and we will send a follow-up email with all of that information as well. I know that I am inspired. I know about all these bills, of course, but just hearing our incredible advocates in the Stronger California Network sharing these bills just makes me feel invigorated and inspired as we enter this final push in the legislative session here, and really want to thank everyone for listening and attending. And we will send you ways that you can engage on these priorities as well as get involved in Stronger California. So look forward to working with you to push these policies across the finish line. Want to thank all of the incredible panelists and hope to see you all soon. Thank you so much.